Woman of the Year award. Here's Michael Harrington.
The University of Pennsylvania has nominated Leah Thomas, a man who is living as a woman, for the NCAA's annual prize. The nomination has sparked outrage amongst true female athletes, both current and former. Legendary women's tennis champion Martina Navratilova reacted to the nomination of Thomas with a tweet that reads, quote, "Not enough fabulous biological women athletes, NCAA? What is wrong with you?" Michael Harrington, SRN News.
The North Carolina State Employee Health Plan will resume coverage of sex change operations for transgender people. That complies with a June federal court ruling that declared the refusal of coverage to be unconstitutional. State Treasurer Dale Folwell and the State Health Plan Board of Trustees call the operations and use of puberty-blocking hormones on children medically necessary services. This is SRN News. Uncle Sam is taking unusual federal emergency measures to save sequoias from wildfire.
The U.S. Forest Service says it will speed up projects to clear underbrush to protect the world's largest trees from the increasing threat of wildfires. The action plan for the summer bypasses some environmental reviews typically needed to cut smaller trees in national forests and use intentionally lit low-intensity fires to reduce dense brush. Raging wildfires have killed up to 20% of all large sequoias over the past 2 years. Some environmentalists are criticizing the plan. Rhonda Rockster reporting.
Officials are warning more stretches of one of North America's longest rivers will be drying up soon. The Bureau of Reclamation will be releasing what supplemental water is left in upstream reservoirs along the Rio Grande in the southwest. Some biologists aren't sure it will be enough to make a difference for the endangered Rio Grande silvery minnow, which the move is designed, to assist. More of these stories at SRNnews.com.
The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Oh, hi there, and welcome to another edition of the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, and we are with you for the next hour to answer your legal questions. 877-943-9673. Live open studio phone lines will get you and your legal question right on the air. 877-943-9673. You can give us a call now. We'll be happy to help any way that we can. We have a full house this morning. We have Yana, the Belarusian producer. We have Brian, the call screener, answering your calls and getting you ready to go on the air with me. And we have Lexi, the intern, with us as well. So full house, and we're here to help any way that we can. You give us a call now. 877-943-9673. That's your toll-free number to be part of our show today. 877-943-9673. And you can always email your question, Patrick at questions 24/7, and I'll be happy to respond as I can. Email during the show, and we'll try our best to answer your questions on the air. That email address again, Patrick at attorneypatricksmith.com, or give us a call now, 877-943-9673. Again, live open studio lines. We'll get your call right on the air. You can be the first caller of the day. 877-943-9673. So today, we've had over the last few weeks sort of a heavier agenda on the show. We were, knee deep in constitutional law with Dobbs versus Jackson and the overturning of Roe versus Wade. And last week, trying to get a little lighter with our guest, Brandon Rhymes, who's always a fantastic guest. And again, a special thank you for Brandon providing such a great perspective on what's on the real estate markets. And then the week before, also talking about claims. So trying to keep it simple and lighter. And to that end, today we're going to talk about planning, which is my forte, my primary practice area. But I thought about, I always ask my gorgeous bride, kind of way to make it more, because estate planning can tend to be a relatively dry topic, a grave subject matter. And at the end of the day, we just tried to find a way to make it more exciting. So the best avenue that I found to do so was to do estate planning of the rich and famous. So we're going to give you some examples of some rich and famous estate plans or lack of estate plans today. and we'll be answering your calls. 877-943-9673. Want to start with one very special estate plan or lack of estate plan, and that of Sonny Bono. Sonny Bono, for those of you who don't recall, the former spouse of the great performer Cher, died tragically in a skiing accident. The problem was he had no will or plan of any kind. So he died what we call in Florida intestate, meaning without a plan, and left it wide open for a lot of turmoil. So there was no plan whatsoever, and that allowed his former spouse Cher to seek spousal support that was unpaid to the tune of $1.6 million. So a lot of unpredictable turns in estate plans where there's nothing in writing, because the state by probate code will fill in the gaps, and you have a wonderful opportunity to 100% prevent that from happening with a good estate plan. So the lesson learned, or the takeaway from Sonny Bono's tragic death without a plan, is that having some modicum of is infinitely better than no at all. It's kind of like binary code. You're either zero, you have a plan or you don't. And Sonny Bono being an example of someone who died with no plan and leaving his estate open to all the delays and expenses associated with that, and especially the hit that he took for unpaid spousal support from his former spouse Cher, $1.6 million. I guess you could say that when she said, "I got you, babe," she meant it. So $1.6 million worth of got you there. 877-943-9673. 877-943-9673. The phones are hopping. Let's go to our first caller of the day. Let's go to Gary in St. Pete. Gary, welcome to the Attorney Patrick Smith Show. How can we help?
Thank you for taking my call. General question around the IRS. So we had an elderly parent who had power of attorney during the last moments of life. And of course, that power of attorney expires with the death. Filed final tax return, submitted the claim for the refund, and unknowingly, kind of mistakenly submitted that power of attorney. IRS replied and said, no, power of attorney is no good. Show that you really have the right to this refund, and I'm baffled as to know what's appropriate next, because I can't get a refund with that. And this is a parent.
Was there any sort of estate planning document, or was this parent like Sonny Bono with no planning at all in place?
No, there's a final will and testament.
Oh, great. I kind of had a hunch there was when you said there's a power of attorney, because that's a component of estate planning, and it would have been kind of unique for them just to have done a power of attorney. So they had a will, and in the will, did it nominate a personal representative, Gary?
Yes, it did.
Okay.
Yeah, and it's right. So is that will the sufficient documentation, isn't it?
Sort of. So the will nominates the appointment of the personal representative. They need to be appointed by a judge in a probate court. So that will empowers you to seek nomination and appointment by a probate judge through a licensed Florida attorney. So at the end of the day, you would have to petition the court. The judge would respond with two orders. One is an order to you called an order admitting will and appointing personal representative. That's telling you that you have been appointed by this judge and you're accountable to the judge for your duties and responsibilities. One of those duties being paying the decedent's taxes. And then the other order is called a letter of administration. That's a skeleton key that allows you to interact on behalf of the decedent with any assets, debts, tax obligations. So with both of those orders in your back pocket, you'll be able to liaise with the IRS, collect any refunds, settle any debt. And also, Gary, just to be clear, I would strongly recommend you work with a qualified CPA. We've had Dwayne Bischoff on the show before, and we'll have him back again. If not Dwayne, someone. I would strongly recommend you work with a qualified tax professional to keep you safe on that.
All right. Appreciate it very much. We'll go back to the attorney that helped us with the estate plan and the will, and I'm sure that we never thought to call him. Never thought about that. Kept thinking about what documentation we would generate otherwise and say, no, we're there.
Well, there you go,
Thank
Gary.
you very much.
Good luck. Enjoy the
Appreciate
rest of
it.
your Saturday. Yes, sir. All right, you're
Thank
listening
you.
to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, 877-943-9673. Again, your toll-free number, 877-943-9673. You can email your question, patrick@attorneypatricksmith.com. Patrick@attorneypatricksmith.com. Today, we're discussing the estate planning of the rich and famous. So you can call in now with your legal question, and in between, we're going to discuss various famous estate plans and lessons we can learn from them. 877-943-9673. Open lines will give you an opportunity to talk with us live on the air. Again, that toll-free number, 877-943-9673. All right, let's go to Tampa. Let's talk to Mike. Mike, welcome to the Attorney Patrick Smith Show.
Good morning. How are you? Thank you for taking my call.
Happy to do it, Mike. How can we help you today?
So I have a question in regards to salary management in Florida. I moved here and I was a salary franchise business. And after a couple months, my staff started asking me, hey, where's this money from the credit card tips? So my question is the franchise owner required to give us that money?
So was there an employment contract between you and the franchise owner?
No, just like a employee handbook.
Okay, so you were
There was nothing in there about that us as salary managers or the staff was not allowed to receive that money.
Yeah, I was going to say if there was some sort of employment contract, you would just look at the four corners of that document and there's your answer, or lack of an answer, as it would be, Mike. At the end of the day, if you're an employee at will, because you were an employee of the franchise, correct?
Correct.
Okay. Yeah, I think at the end of the day, it's really going to be up to that employer's discretion. Again, I don't do a lot of labor law, but I do work with some great attorneys who do practice in that area. And I'll be happy to put you in touch with one of them next week who can sit down with you and give you the best answer to that question. But my hunch is, as the employee, you're at the will of the employer as far as how they're going to compensate you and if they're going to change that compensation without an employment contract.
Okay.
All right,
Tell
Mike.
me.
All right, Mike. Just give out the office number later in the show, so you just have a pen and paper ready, and you can write the number down. Give me a call next week at the office, and I'll put you in touch with a great labor law attorney who'll get you a great answer. Okay.
All right. I appreciate your time. Thank you very much.
Thank you, Mike. Enjoy the rest of your Saturday. Okay.
You do the same.
All righty. 877-943-9673. 877-943-9673. That's your live and local number to be part of our show. Encourage you to call in now. Open phone lines, 877-943-9673, 877-943-9673, or give us an email, patrick@attorneypatricksmith.com, and we'll be happy to answer your email question as well. So the next estate I want to talk about before we go to Susan's call is the estate of Casey Kasem. So number 2 on our list, those of you who are not familiar, Casey Kasem hosted the Top 40 Countdown for years and is a radio legend and one of my inspirations in doing a live radio show. There was a huge fight in Casey Kasem's estate regarding the disposition of his remains. So it took over 6 months for Mr. Kasem to be laid to rest because of the lack of memorialization of his wishes as remains should be handled. So there is a lesson to be learned here. Not only is it important to have a plan, but one of the most important things to address your plan is, how do you want your final remains handled? And then with our clients, we always put these forms as supplemental documents. And that way, if people change their minds about these particular details, they don't necessarily have to pay for an amendment to a trust or a codicil to a will. They can make these changes in the privacy of their home, and they can also articulate these facts in the privacy of their home. They don't necessarily have to discuss them with their attorney. If they want to keep these more intimate family details private, they can do so on these supplemental forms. Important thing here, don't find yourself in a spot like Mr. Kasem did, where you have a situation of the family has a dispute. Half the family says the remains should be disposed of this way, and the 100% avoidable by just memorializing and codifying in writing your wishes, letting the family know what the right answer was so that they can just sit back and honor your wishes. So 877-943-9673. Give us a call now, live and local. We're discussing estate planning of the written phase 7, 943-973, or email me, patrick@attorneypatricksmith.com. All right, next we're going to a very patient Susan in Venice. Susan, thank you for your patience and welcome to the Attorney Patrick Smith Show.
Well, thank you for taking my call. And I'm not part of the rich and famous, but I'd like to hang on to what I have. And I have a question about.
Just add a yet to that, Susan. You're not part of the rich and famous yet.
Oh, okay. Well, that could happen, right? I'm being interested about umbrella insurance, and if you don't take that, is there any coverage or insurance with a revocable trust?
Not with your standard revocable trust, because you still have access to the assets. And, you know, when we look at it from like a Florida statute 222 analysis, asset protection statute here in Florida, if you have access, odds are your creditors can get access to it as well. And I'm a big fan of umbrella insurance. I have it myself, and I recommend that everyone out there speak with a qualified, licensed insurance representative and see if it's an appropriate thing for them to consider and kind of what levels they should have in terms of umbrella insurance. But the typical revocable trust does not provide an automatic creditor protection. However, it doesn't hinder it either, Susan. So, Susan, not to get too personal too fast, but are you married?
No.
Okay, so with a married couple, to be clear, they own property tenants by the entirities. Now, that's a special way to own property in Florida. And when same-sex couples were pushing hard for equal rights, this was one of the equal rights that they were pushing so hard for, because when you want to own property tenants by the entirety, there are something called unities. Now, not to get too deep into the pool at 8:17 on a Saturday morning, but these 5 unities are time, title, interest, possession, and marriage. Well, the problem with same-sex couples, they could not legally marry, so they couldn't own property tenants by the entirety.
Mm-hmm.
Tenants by the entirety property has credit protection. Now, if you own the property with a husband and wife scenario, you have creditor protection, meaning they have to be a creditor to both husband and wife, or both spouses, in order to seek that property. The trust, if it's a joint trust between a husband and wife, can preserve that tenants by the entirety's protection. So while the trust may not add any additional protection, it can preserve the protections that are already in place.
Does a single person have any, for instance, on a home resident, have any protection in Florida that they can't come after the house if it's a homestead?
Yeah, that's exactly the follow-up question I was going to ask, Susan. Is this your homestead property?
Yes.
So it's within the city limits, or you're outside the city limits?
In the city.
So are you less than half an acre?
Yes.
Okay. So under the state constitutional analysis, this would be your constitutionally protected homestead. It's bulletproof. You are Teflon from creditors except 2. Okay. There are 2 exceptions to this. One, ad valorem property taxes. So if you don't pay your property tax bill, obviously they can put a tax lien on your property. And then the other one is called a mechanic's lien. So if you hire someone to come on the property and improve the property in some way, and you do not pay them, they can lien the property. But other than those 2 exceptions, you're bulletproof already. And transferring the property into the trust, as long as it's recognized as homestead property, both in the conveying deed and in the receiving trust, your homestead protection can remain uninterrupted, Susan.
So the only thing that they could really come after would be a bank account that might be in the trust?
Potentially. I mean, a cash account would be one of the most commonly exposed items. Yes, ma'am.
Okay. All right. I appreciate the help, and I certainly enjoy listening to you every Saturday. So keep it up.
Susan, I appreciate your kind words and your faithful listenership. Thank you so much. Enjoy the rest of your Saturday. Yes, ma'am. Bye-bye.
Yeah, thank you.
All righty. You're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673. 877-943-9673. We are live. We are local. We are happy to help any way that we can. You give us a call now. Open phone lines. 877-943-9673. Or email me, patrick@attorneypatricksmith.com. Email me, patrick@attorneypatricksmith.com, your email question, and we'll do our best to answer your question live on the air. Today, we're discussing estate planning of the rich and famous. To be part of the show, 877-943-9673. All right, next, let's go down the street from where I live, Indian Shores, and let's talk to Dave. Dave, welcome to the Attorney Patrick Smith Show. How's the neighborhood this morning, Dave?
Well, as I told your reception host there, I'm actually spending the summer in Connecticut.
Oh,
so,
my gosh. So you do have no
but it's
idea
actually,
how the neighborhood is.
Yeah, the neighborhood is fine here, except it's probably a couple of degrees warmer up here than it is down there right now.
Really?
Yeah, it's very, very hot up here. But that'll change next week.
All right. Well, how
Anyway,
can we help you today, Dave?
Yeah, well, my wife and I had a trust, whatever you call it, organized or created last year, middle of last year, and unfortunately, she passed away later in the year. But
I'm so sorry, Dave.
and we updated. I updated. Oh, thank you. I updated the trust after that happened. And so, an addendum. I guess my question is Schedule A more or less a living document where, you put in things, you take things out, that kind of stuff, and you just keep updating that Schedule A without having to go back and have any type of, attorney review?
Yeah.
Or how,
With trust up to speed on what schedule exactly. So when you create a revocable trust, it's like a safe. You can put assets in, you can take them out again, you can change it throughout your lifetime. It's a very dynamic document that way to be adjusted with assets being funded and defunded throughout your lifetime. Schedule A is where you have basically a table of contents of the current assets, the current corpus of that trust. It's designed to tell your successor trustee, the person who is the counterpart to a personal representative or executor under a will, it's designed to tell them where to find all your stuff when you've entered eternity. So the short answer to your question, Dave, is yes, you can change it. Most of my clients, what I've discovered is they basically create a home document on their word processor or home PC, and they print it out once a year and paperclip it to the last page of the trust and Schedule A. So another common misunderstanding with Schedule A's, Dave, is a lot of people think, well, as long as I write an asset on Schedule A, that means it's in the trust. That is not the case. There is no transfer feature to Schedule A. It's simply a memorialization of the fact that you have previously transferred. So I give bank accounts are a great example. If you've gone to the bank and moved the account to the trust, then you can list it on Schedule A. But simply listing my Wells Fargo checking account on the Schedule A does not mean it's in the trust. But yeah, it is something you can change throughout your life, and you don't need an attorney's involvement to update your Schedule A.
Yeah, that's what I thought. I just wanted confirmation. I mean, I also created a document of items that weren't in the trust, and I just kind of put that at the end, and then items that the trust becomes the beneficiary, that kind of stuff. That went in too, because I guess that's really not a Schedule A situation.
The other item that you mentioned sounds something to the effect of like a separate writing under Statute 732-515, which is for like heirloom jewelry, artwork, family Bibles, items that may be significant, and you want to make clear as to whom the recipient is. Is that what you're alluding to?
It was, yes.
Okay.
And actually, my wife had jewelry or whatnot that she bequeathed to her niece, which that was already taken care of. So that was, yeah, that sounds good. That's what I'm trying to do is, get things in order, even though I'm not planning on leaving this earth quite yet. But in any case, what I went through when my wife passed away, and I thought everything was pretty much in order, you find out that, oh, I forgot about that, or I forgot about this, and takes some doing.
How many years were you married, Dave?
A little over 43.
Oh, Dave, I'm so sorry. I've only been married 19 years, and I can only imagine losing a best friend of 43 years. I'll say a very special prayer for you, Dave, and that's tough. That's tough, Dave. But it sounds like your estate plan's in good shape, and just stay on top of it with your attorney with those periodic reviews every 3 years or so, or if not sooner, if there's some major change in the family. But you're doing a great job, Dave. Keep it up.
Thank you very much, attorney, and I love listening to your show.
Hey, speaking of that, how are you what station are you listening on now in Connecticut?
What is it? 86, The Answer? Is that what it is?
AM 860? All right. Well, we appreciate you listening on AM 860, and we'll let Joe Weaver know this is Connecticut. Terrific. So,
thank you very much.
All right. Thank you, Dave. You too. All right. You're listening to the Attorney Patrick Smith Show. I'm 879-439-9673. We're live. We're local. We're here to help any way that we can. 877-943-9673. Today, we're discussing the estate planning of the rich and You can call in, be part of the show. Walker, his franchise, he passed away at age 40, and his estate was worth approximately $25 million. And he actually did have an estate plan in place. So this is an example of someone who did a plan, but because of a failure to update the documents, it led to significant delays because of the valuations and assets and how much they had fluctuated since he had originally done the document. It had actually been over a decade since he had created the instruments. So had a plan, let it sit for over a decade, never revisited it or updated it, and then passed away tragically and experienced some inefficiencies and delays because of that failure to update. So this is a great example, and the lesson that we can learn or glean from this is that not only do we want to have a plan, we want to have the best plan, and that requires revisiting the plan periodically. They just told Dave, you sit down with your attorney every few years. I recommend every 3 years at the most, or if something major changes in the family, new births, deaths, if we have a situation where the estate increases in value, or if we have an estate that decreases in value significantly, you may want to consult with your attorney about that and see if the family, the finances, the documents all still optimally align. Remember, the goal here is to find the most efficient passage of the wealth to the family. So we want to get as much of the wealth to the intended beneficiaries as quickly and efficiently as possible. So to do that, not only do we need an estate plan, we need an up-to-date estate plan. So you want to make sure that your situation is not like Mr. Walker, who I'm sure did not expect to pass away at 40, but you want to make sure that you don't let it sit for over a decade, that you have it reviewed periodically to make sure everything is optimally drafted for your family. So 877-943-9673, open phone lines. We'll get you and your call right on the air. 877-943-9673, or shoot me an email, patrick@attorneypatricksmith.com. Next, we're going to Beverly in Port Charlotte. Beverly, welcome to the Attorney Patrick Smith Show.
Yes, it's my first time, and I don't have any ready for when I die. No will, no nothing. So I'm really lost on this. And a guy had told me from work that if you, I guess for your trust, you can make sure that your house is taken care of before you die, so that way your kids will get the house without paying any taxes.
So estate taxes, Beverly, it says you're calling from Port Charlotte. I presume you're a Florida resident. Is that correct?
Yes.
So
yes, I live here all the time.
So, well, thank you for listening. And so the short version is, with federal estate taxes being north of 12 million, most estates are not paying any estate taxes. And when we run an estate through a tax analysis, there's 4 taxes that we like to look at. There's the estate tax, the generation skipping transfer tax, the gift tax, and the income tax. And you sort of run through all of those. At the end of the day, it's extremely rare to see someone's paying estate taxes. That's just statistically not very likely with the exemption so high. So your goal would be, presuming the estate, you don't have to say this over live radio, but presuming the estate's under 12 million, your goal would be avoiding probate. Under Florida code, outside of any exemptions, formal probate begins at $75,000. So at the end of the day, it may be most optimal to have the asset in the trust so that the family receives the money via the trust and gets to skip the 14 months on average, an approximate 3 to 10% in fees for the probate procedure. So that's probably what your friend was alluding to, is putting the home in the trust to have it bypass the probate list.
Yes, and I don't know who to go see or what to do, how to set this up, because I don't even have a will.
Well, we'll be happy to help you with it, Beverly, if you're currently shopping for a new attorney. I'll give out the office line here in a few moments, and you can give us a call next week, okay?
Okay, thank you.
You're welcome, Beverly. Enjoy the rest of your Saturday and enjoy Port Charlotte, okay?
Okay, thank you.
You're welcome. All right, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673. 877-943-9673. Today we're discussing the estate plans of the rich and famous. So far, we've discussed the estate of Sonny Bono, discussing how having no plan at all can produce a lot of turmoil and delay and unanticipated claims for spousal support, like your wife Cher in that particular scenario did to Sonny. We discussed the estate of Casey Kasem, discussing how, maybe not necessarily the memorialization of the money producing the issue, but putting in writing how you want your remains to be handled can produce drama and expense, and in his case, a 6-month battle over how the remains were to be handled. And lastly, we talked about Paul Walker, who actually had an estate plan, but hadn't updated it in over a decade. And that led to some additional delay because of the valuation issues that changed in his estate over that 10-year plus period. So 877-943-9673 or email me, Patrick at attorneypatricksmith.com. Next, we're going to Tampa. We're going to talk to Jonathan. Jonathan, welcome to the Attorney Patrick Smith Show.
Hey, sir, how are you?
I'm great, Jonathan. How can we help you today?
Good. Hey, thanks for your time and great advice for everybody. I'd just like to say that up front.
I appreciate that, Jonathan. Thank you.
If I can summarize this very quickly, in the middle of a divorce, 10 months, day of filing was 3 September. Went to purchase a second house to get custody of the kids. When I went to get the house in Florida, you can't buy a house without your spouse's permission. She refused to buy. I purchased a home. I had to convert it to an investment property because I couldn't buy it without her permission. The question I have for you is converting an investment property into a trust while I'm still married and then moving the homestead from the marital home to the investment property. Best advice for a trust, not a trust. How do I capitalize on that?
Well, Jonathan, I have to be very careful. Are you represented by an attorney in this?
For divorce, I do have a divorce attorney. That is correct.
All right. So I'm going to stay away from the divorce side of it then, since you're represented by counsel
Right.
there. However, the estate planning side, it sounds to me like what you're running up against is the state constitutional restriction under Article 10, Section 4 with regard to alienation of homestead property or transfer of homestead property. Now, the way the Constitution states this, the Florida State Constitution, so don't start looking in the federal Constitution, guys. You won't find it anywhere. But the Florida State Constitution, Article 10, Section 4, for those of you who like to look it up, says it in the affirmative. It says you may transfer or alienate, is actually what it says, a homestead property with spousal joinder. But it's the converse that really shows us the rule, Jonathan, when it says you may not alienate or transfer without spousal joinder. So if you own a homestead property and it's in just your name, you go to sell it, but you're married, spouse will have to join in that conveyance. Now, this is why a lot of you right now are saying, oh, that makes so much sense now. Why? When I refinanced the house and it was in just my name, they still made my spouse sign off. Now you're beginning to connect the dots because the transfer, the alienation, anything to do with that homestead property requires spousal joinder. Now, you mentioned the purchase of the property. That's the first time I'm hearing this, Jonathan, because you can buy the property in your name alone. It's just you can't convey it away without the spousal joinder. So you're telling me that a title company told you that you could not purchase the property unless your spouse joined in the purchase?
Right. As an owner-occupied property, if you're married, the wife has to sign the deed because you're married.
So
even though she doesn't.
You were taking out a mortgage then?
Yeah.
Okay, so not
absolutely.
a cash deal. So this was probably a requirement of the lender, less the state constitution. It sounds more like a lending requirement in this particular scenario.
Okay, I didn't know that. I was told that was a state law. So
yeah,
thank you.
I'm still running up against where it says that the spouse has to be part of the original purchase. I know they would have rights to it, but I'm not sure that they maybe. Go ahead.
So what they told me, since you're married in the state of Florida, when you buy a home, the wife has to be recorded on the deed. She doesn't have to be on the loan, but she has to be on the deed because you're married. And if you tell me that's not true, then I got swindled because I had to buy the house at a higher interest rate as an investment property, and non-owner occupied was the only way I could purchase it while I was still married going through a divorce.
Yeah, I'm not sure that there's any law that says that the spouse had to be on the deed because, I mean, think about that. That would just say that you were going out and buying a property. You could buy the property, but I mean, maybe this is some new cool hip law that I just don't know. I doubt, Jonathan. At the end of the day, it's a situation where the alienation rules are pretty clear. Did they cite a particular statute? Do you recall that? Or did they say it was the state constitution?
It says state law, is what they told me.
Yeah.
So I better consider it. Now that I bought the second property as an investment property, non-owner occupied, but it is while I'm going through the divorce. Do you recognize me for the tax write-off? Now that it's investment property, I can write all that stuff off. But my question to you is, should I put it in a trust or leave it in my name as a investment property,
So-
even though I'm residing in the bank?
Yeah, so
Sorry.
this is non-homestead property, right?
Well, I applied for homestead, and since I bought it January 3rd, you had to own it January 1st. So both spouses have homestead exemption. So they're going to leave the homestead on the marital home for the wife, and then effective January 1 of 2023, I can apply, which I did for homestead, for the investment property, and they're going to give it to me, supposedly.
Yeah, I think you'd probably be best served, Jonathan. I don't think I want to answer that question fully on the air because it's a precarious answer. So I'll give out the office number. You can set up a complimentary consultation. I'll be happy to sit down with you in the privacy of the office. I just don't want to give you the best answer because I'm not sure that it's in your best interest that answer go out over the air. I just know that there's some interesting and definitely some relevant facts that you should be aware of before you do any of that, Jonathan.
Thank you, sir. I appreciate your time. I'll call your main office and set up a consult. Thank you.
Jonathan, we'll look forward to seeing you. Okay. Good luck with everything.
Thank you, sir.
Yes, sir. All right, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673. 877-943-9673. Give us a call now, live and local, open phone line. We'll get you right on the air. 877-943-9673. We're taking your legal questions, and in between, we're discussing estate plans of the rich and famous. So to be part of the show today, you can always email your question, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com. And the number to be part of the show on the air, call in now, live and local, open studio lines, 877-943-9673, 877-943-9673. I did promise the office line to a few callers. So the office number, if you want to schedule your appointment, and lots of people, we're seeing more and more clients coming in throughout the week that say, hey, heard you on the radio, love the radio show, and I appreciate that. And definitely tell the radio show is continuing to grow in popularity. And we appreciate you guys listening, and we appreciate you guys calling and setting up your complimentary estate planning consultations. That number to do so, 877-754-6764. Again, that toll-free number to reach us at the law office, speak with me or any of my staff, 877-754-6764 to set up your complimentary consultation at the Sarasota office, the Sun City Center office, our office in Claremont, or the Villages. 877-754-6764. Office is also in Winter Haven to serve you, and Apopka. So to set up that complimentary consultation or to book us to come and speak to your club or group, we've done that quite a few times and still booking lots of events as we get ready to go into the fall here. If you want to book us to come out and speak to your club, group, or organization, 877-754-6764. So that's your toll-free number to reach us at the office during the week, Monday through Friday, 8 a.m. to 4:30 p.m. And to talk to us here live on the air this Saturday morning, 877-943-9673. Again, your toll-free number, 877-943-9673. And you can email your question, patrick@attorneypatricksmith.com. And speaking of attorneypatricksmith.com, that is the website. Check it out. Recently revamped. We're still taking your feedback, and we love it. We appreciate all the kind words and praise for the website. We worked hard to make it so user-friendly for all of you. So check it out, attorneypatricksmith.com. You can learn more about me, the office locations, our services, our rates. You can listen to archived radio shows on demand, so you can pause, rewind, and go back and listen over and over again, and many times as you want, our discussion on Dobbs versus Jackson, homestead law, small claims matters. You can go back and educate yourself and re-educate yourself as often as you like. All that's available free of charge to you at attorneypatricksmith.com. All right, let's take our first email question of the day. Let's go to Lexi, the intern. Lexi, the floor is yours.
Thank you. So our first question says, when is it necessary to have a trust? Also, is it necessary to have a will with a lot of legal jargon?
So we have people all the time that say, I want the estate plan to be as simple as possible. And I think that when it comes to simplicity, it's really a matter of just customizing or tailoring the drafting and trying to avoid like pro forma as much as possible. I think that's where you get lost in the weeds and you get the legal jargon, as the question said. I think the threshold for a simple trust, because there are many, many different kinds of trust, and I think the simple trust threshold is $75,000 outside of any exemptions. That is the threshold for formal probate under our probate code. Disposition without administration is the simplest type, and that's for estates of about 6,000 or less. Over that, up to 75,000 is a summary administration, and then beyond 75,000 is a formal administration where the probate process will kick in and take full effect. Notice to creditors, publication and inventory, statement regarding creditors, whole 9 yards. And that's on average about 6 to 14 months, depending on the county, and on average cost is anywhere from 3 to 10%. So I recommend considering the simplest type of trust at about $75,000. And we'll talk a little bit here more about some more advanced trust planning and when does a simple trust not cover the estate plan. So if you want to be part of the show, great email question, by the way, 877-943-9673 to be part of our show today, 877-943-9673, or email your question, Patrick at attorneypatricksmith.com. All right, let's go to Spring Hill. Let's talk to Bill. Bill, welcome to the Attorney Patrick Smith Show.
Hello, how are you doing today?
I'm great, Bill. How are you?
Oh, I can't complain. My question is, Mom is 73 years old. She pays a mortgage. If Mom passes, my brother and I would not have any right to the house, I think, correct?
So Mom passes, home is in her name alone?
Yes.
Is she married?
No.
Okay.
Widowed.
So
Mom has not passed yet. She's still with us.
okay, so Mom's with you now. She's not married. Obviously, if she does marry, that'll change the facts and the answer to the question. And it's just you and your brother. You're the only two siblings?
Yes.
Okay. So the heirs at law on this fact pattern would be you and your brother. I mean, it would still be in her interest to at least do a simple will to memorialize the fact of who she wants her beneficiaries to be, the contingents, the administrators, and it may even be in her best interest to go a little beyond a simple will to something like a simple trust to bypass the probate process. But absolutely, she should at minimum have some sort of simple plan in place.
Okay, but my question is, as far as the mortgage, with no one else being on it and the house still being paid on, she can't will the house to us if the creditors still basically own it, correct?
No, she can. It's just a matter of the creditor is going to have to be satisfied. So you guys are going to have to pay that creditor, either refinance the debt in your name or sell the home and then take the equity. But it doesn't, the mortgage does not stop Mom from bequesting or devising the property to her heirs.
Oh, okay. Well, that's a lot better than what I was assuming.
Yeah.
Is there a way to put one of us on that note now?
I wouldn't
Like
recommend that.
refinancing or something.
Yeah, I don't know that I would recommend that. I think that might affect your capital gains basis adjustment. It could also trigger some gift taxes if the equity in the house is beyond the present interest annual exclusion. And anytime you get into those sort of tax waters, you want to make sure you got a good accountant watching your six. The most typical methodology there, if your goal is to avoid probate and provide for a seamless probate-free transition, it's going to be through creating some sort of simple trust. But it sounds like your mom just needs a good consultation with a qualified estate planning attorney to get her pointed in the right direction.
I agree with you. I would definitely recommend you to Mom.
Well, I appreciate that, Bill. Thank you so much. Enjoy the rest of your Saturday, okay?
You too.
All righty. You're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, and we are with you, and we are here for about another 7 minutes or so to answer your legal questions. 877-943-9673. 877-943-9673. Before we go with Andrew in Palm Harbor, we're going to talk about our next estate, which is the estate of Philip Seymour Hoffman. Now, Philip Seymour Hoffman's estate was an interesting one because he actually left a will in an estate of about $35 million, but he left it all to his companion. All right. So he was never legally married. And at the end of the day, he had 2 children after he drafted this will. So it speaks to the fact of what happens of what we call a pretermitted child. So someone had a situation where they did a will and then subsequent they had children. So the Florida actually had, now Philip Seymour Hoffman was a resident New York State. But the odds are you're a Florida resident. So your interest statute, which is Florida Statute 732-302, regarding pretermitted children, and it says when a testator omits to provide by will for any of his or her children adopted after the making of the will, and the child has not received a part of the testator's property equivalent to a child's part by way of advancement, the child shall receive a share of the estate equal equal in value to that which the child would have received if the testator had died intestate. So this is a this is basically Florida public policy saying we're going to protect children for people who did wills, then had children, and more than likely just forgot to update it to protect those children. So Florida statute 732-302, and again, it kind of goes back to the Paul Walker scenario about making sure you stay on top of updating your estate planning documents. And one of those events that triggers a review with your attorney being a birth of a new child would certainly trigger a review of your document and make sure everybody's included. So 877-943-9673. Give us a call now or shoot me an email, patrick@attorneypatricksmith.com. All right, let's go to Andrew in Palm Harbor. Andrew, welcome to the Attorney Patrick Smith Show.
Well, thank you for taking my call, Patrick. A question for you. I have purchased a couple of houses for my children, okay? They wanted to buy the houses, and I took the money out of my retirement fund and my retirement savings to pay for the houses for them, and they're giving me the money back. Is there a problem with that?
So it sounds more like instead of a gift, you loaned them the money. Did you memorialize the loan with a promissory note of some type, Andrew?
Well, what I did is I put their name on the deed. In case I die, it automatically goes to them.
Yeah, there may be some gift tax exposure there. There may also be some liability exposure. With you guys all being on the deed, you can't have two homesteads. And if someone's in a car accident, and then that property could be subject or attached under that litigation. So, yeah, you definitely need to sit down with a good estate planning attorney, Andrew, and have all of that reviewed and make sure that everything's optimally structured. I kind of see where you're headed and the goal that you have, but I'm not sure that adding kids' names to the deed's the most optimally efficient way to do it.
Do you think I should put everything in a trust?
I don't know.
Because I still haven't done that yet.
Yeah, I don't know, Andrew. I don't know enough about your estate, but I'm happy to give you a free consultation. We could sit down in the privacy of my office here in Palm Harbor, so we could sit down in my office in Clearwater and just go over everything start to finish and give you a free consultation to make sure you get the best advice, okay?
But that sounds great. That sounds great. I'll be giving a call and set up an appointment.
Andrew, I'll look forward to meeting you in person. Enjoy the rest of your Saturday, okay?
Thank you, sir.
All righty. 877-943-9673. Nick, I'm going to get to you in just a second, but to get my last estate out of the way on our estate planning of the rich and famous, we're going to talk about the estate of Joe Robbie. Joe Robbie, the founder of the Miami Dolphins, and this is a great example of insufficient planning. So Joe Robbie had a plan in place, and then unfortunately, when he passed, had not adequately structured the plan to cover his estate taxes. So he had an estate tax bill of $47 million, could not pay it, didn't have the liquidity, so he had to sell off basically his interest in the Miami Dolphins and assets in order to pay the estate taxes. So this is a great example of, for you higher net worth estates, having a good plan in place that's going to accommodate for that net worth and anticipate estate taxes. Now, granted, Mr. Robbie died in 1990, and the estate tax exemption was much lower than it is today. It's about $12 million. But at the end of the day, for those of you in that higher net worth category, you may want to consider something called like irrevocable life insurance trust. That are these insurance policies you buy in the separate trust, and they're irrevocable. So they're outside of the scope of your ownership under Internal Revenue Code Section 2038. And as long as you don't exercise any what we call incident ownership under 2042, this money's tax-free. And it can be used to pay your tax bill or to buy assets from your estate. So it can be used to protect the family from this liquidation like the Robbie family experienced. And oh yeah, by the way, under 732-201, Elizabeth Robbie was able to take a spousal elective share claim to the tune of a 30% share of a $70 million estate. So you also want to make sure you've got a good nuptial agreement in place to address any unanticipated spousal rights issues. All right, let's go to Nick and Brandon. Nick, welcome to the Attorney Patrick Smith Show.
Well, thank you for taking my call, Patrick.
Happy to do it, Nick. How can we help today?
Okay, Patrick, I have a will. I'm retired. My wife's retired. We own our home. But I'm a little bit confused on when probation kicks in. I'm trying to avoid probate, and I have 3 children. We have a will, and basically in the will we said if I die first, everything goes to my wife. When we both die, everything goes to the kids, split 3 ways, and that's the basic essence of the will, which is now several years old. But I have a relative who recently died, and they said they're waiting on probate. And I'm thinking,
Yeah.
I wonder why they're waiting on probate.
Hey, Nick, I'm going to cut you off only because I have about a minute here to wrap up the
Okay.
show. The short answer is this. Probate is defined as the court-supervised transfer of assets from a deceased person's name to the appropriate living beneficiary. You remove the deceased person's name from the equation with a living trust often. The living trust can hold the assets. Then when you pass, nothing's in a deceased person's name because that would be your trigger for probate. To go back to your original question, everything's in this living trust, and it's going from living trust to living beneficiaries, and therefore we have successfully avoided the probate process. And Nick, I'm sorry to rush your call, but I got to wrap up the show. This is the Attorney Patrick Smith Show, 877-943-9673. That's your toll-free number to be part of our show. Next week, 877-943-9673. Thanks for tuning in to our edition of the Estate Planning of the Rich and Famous. To reach me at the office during the week, 877-754-6764. You can check out our website, attorneypatricksmith.com, or shoot me an email, patrick@attorneypatricksmith.com. All right, this is Attorney Patrick Smith signing off, saying God bless, stay safe, and go Gators.